Hello, everybody, and thank you very much, Laurel, for giving me the opportunity to go live on Facebook. I'm Roger Levitt, and I'm a business and property mediator. A number of you will already know me as the man in the middle, and I'm going to explain a little bit more today about what being the man in the middle means. I joined Laurel's networking group soon after it was set up, and so I feel very much part of the furniture, and I've been watching as it's grown steadily under Laurel's expert guidance and leadership. So I'm a business and property mediator. Let me first explain a little bit about mediation. A wireless glitch. What I was saying was that because mediation is a collaborative exercise, it's very important to have comments and feedback as we go along, so that you're part of the process. So don't feel any hesitation in asking any questions as we go along. So what does it mean by being the man in the middle? As a mediator, my role is to help people find a solution that works for all of them. Now, that might seem very simple, but I'm sure that those of you who have been involved in disputes of any sort will know that it isn't that straightforward. But the key to my role in helping to enable people to find their own solutions is that I must be completely neutral, completely independent, and completely objective. Now, what that means is that I mustn't know the parties, I can't be connected, and as long as that's the case, then I'm free to help from a completely dispassionate and non-emotive way. Most of the disputes that I get involved in helping with, I find, are where people have doesn't usually happen in this location. So I was explaining the importance of being neutral and the importance of being not connected to the emotion in any way, because most of the disputes that I get involved in are where people have got stuck because they are stuck in the emotion, the ego, the pride, or principle. Matters that would otherwise might seem simpler to resolve become stuck because people dig themselves into positions which they can't get out of, because they're convinced they're right, the other party is wrong. They are stuck in the emotion, they're stuck with the ego, and they're stuck in their pride and in the principle. I've been writing a little bit recently about the Brexit negotiations. Now, to me, they are a classic case where mediation can help considerably. We have negotiators on both sides who, for political reasons, seem to need to present to their audience a particular line and a particular position. From a negotiator's point of view, it doesn't make any sense at all to me, because the whole purpose of the negotiations should be that we're looking to try and find a resolution with our friends and European partners to work from everyone's point of view. But certainly the negotiations that I've seen, certainly the way in which it's been presented politically, shows no sign of any of the core attributes of mediation and negotiation that I'm used to. So I think we're now up to 6 sets of meetings and negotiations, and it looks pretty much that we made not much progress at all, which just doesn't make any sense. And if the parties had a proper trained negotiator or negotiators in place, then they would be looking at working out how to meet each side's needs and interests by reference to what the other side are also looking at, and not just banging on about what we need and what we want. And they would be looking at the areas of common ground in order to bring them together. Now, clearly, any mediators couldn't possibly come from the UK or Europe, but there must be plenty of suitably qualified mediators of stature and experience from around the rest of the world. Now, the only things that we seemed to be able to agree with the negotiators from Europe are that we are running out of time, that we are going off the edge of a cliff, although I don't think we can agree what cliff it is, and that the ball is constantly in the other party's court. Well, that is, to me, that it doesn't make any sense at all. Now, if I was involved, if I had charge of the whole process, then I think that it would have been useful to bring in mediators right from the very beginning, because the whole tone, the whole approach of the negotiation has been confrontational, has been position based, and it hasn't been about let's look at what we've got in common, let's look at how we can achieve a result. It's let's look at what they're doing wrong, what they're not doing in order to try and make this settle. So that's an area of huge frustration. Looking above the political approach of how we're getting on with Brexit, it's how can we best use the negotiating time that we've got, assuming that this is going to happen, and how can we use it so that we can maintain the relationship rather than help harm it, because certainly the negotiations so far, there's been plenty of evidence that the relationship is being sorely tested, and so I think that it's something which I haven't seen broadcast very often, but certainly that would be something that I have been promoting and I would hope that it might have some traction. So what are the sort of disputes that I get involved in? I get involved in a whole range of disputes. In very simple terms, as I said, what I'm looking to do is to try and help people to find resolutions of disputes that they can live with. Now, what they can live with usually means considerably less than they were looking for in the first place. But anybody who's been involved in a business dispute, anyone who's been involved in a personal dispute, will know that life is about compromising, and it doesn't necessarily mean splitting something down the middle, but it means finding a way of resolving a dispute so that you can put it behind you and get on with your life. That is so important. It's so powerful. The ability to resolve a dispute in a way that does work on both sides is hugely cathartic if you've been involved in a dispute where it drags you down, it takes over. And the aim of mediation is to help people to come to these conclusions and these settlements without the need to go to court, or if you have already gone to court, even for preliminary hearing, that you should be able to close down the dispute, because that is in the interests of the people concerned, it's in the interests of their pockets, it's in the interests of the courts, who are hugely overloaded with disputes, and I'm only too pleased to have a case removed from their list. The courts are more and more now looking towards making directions to parties in disputes who the courts say should be going away and settling this without wasting the court's time. So there is a trend towards mediation from the courts. There is also a strong move towards mediation from the fact that in order to issue a claim is very expensive, 5% of the value of the claim. So if you've got a £200,000 claim, you're going to have to spend £10,000 just to issue, and that really does make you think twice. What that has led to, in my experience, is more people trying to bring in mediation, trying to bring in negotiation before issuing. It may be that they mediate based on a draft set of particulars of claim, i.e. as if they were going to go to court, but they haven't issued. But in my experience, it's good that people are looking to mediate much earlier in the process. Now, one question that I'm often asked is how early in the process. I can think of an example of a recent mediation I got involved in, where I was mediating between two directors of a company, and they had been good friends. They had set up a company. The company had been successful, and it had been going for 8 or 9 years. And then in the 10th year, the directors fell out, and they fell out to the point where they agreed that they wouldn't be continuing the company, they would separate. And it's taken a year for them to get to mediation. Now, we've had a mediation meeting, we've had discussions after the meeting, and I would say that they're certainly making progress in moving towards each other, but they've still got quite a way to go. Would it have been more helpful if they had come to mediation a year ago? Well, certainly it would have saved them £10,000 to £15,000 each on legal fees. The lawyers may have said, well, we needed to get involved to scope out the claim and defence and counterclaim, which is fair enough up to a point, but it doesn't explain the period from, say, the end of month 1 or 2 to month 12, where there were negotiations backwards and forwards, but didn't get anywhere. The catalyst of having a meeting with a qualified mediator who can bring out from each party the issues that they need to be negotiating on makes a huge difference. Just getting involved in the process, getting involved in getting a position statement together, which could be a culmination of, in this case, 12 months of negotiation. But if it had been nipped in the bud, say between month 1 and month 2, I think that the likelihood of a negotiated settlement would have been as strong, and it certainly would have saved the considerable fees that have been incurred since then. So that's an example, a very fresh example of how I think that mediation can help sooner rather than later. So what do we do about the examples of people who have cases where they feel that it really is important to throw the book at someone, that their behaviour has been so bad, we need to treat them a lesson. We need to make them understand that they have been so wrong that that it won't be solved by mediation. So what I would say to those sorts of cases are, clearly there are situations where you need to do that, to set out your position very clearly, and to give the other party the opportunity to reply, or maybe have no reply. It still doesn't, in my view, prevent a mediation taking place after that. And so in that case, I would still put this into the category of the director's dispute, which I've just described, where once you've set out clearly your position and what you will be doing if the other party doesn't do X or Y, that doesn't then prevent a mediation taking place. And you could even look at it as a case of good cop, bad cop. The mediator helping to try and negotiate a quotes friendly solution, but with the threat that if that form of negotiation doesn't work, that you can always then revert to the bad cop. So mediation can be very flexible in that way. What other types of disputes do I get involved in? I'm a property solicitor, and I've been involved in property law for over 30 years. I get a lot of property related disputes that run from boundary, access, rights of way, trespass, between neighbours, between flat owners, and on the other hand there are commercial property disputes which might involve rights of light, service charge, disputes over landlords or tenants repairing obligations, dilapidations at the end of the term of the lease. And I find that with property disputes particularly, it's essential that I go and see the property before we have the mediation. Now, if this is a boundary dispute, it's although it's not a decision that I can take based on my knowledge of property law as to whether or not a particular line is in the exactly correct position, because as those of you who will know the way the final plans work at the land registry, they're not drawn to the precise calibration that we might like. In such a situation as that, I would ideally like to have a building surveyor involved as well, if it really is a question of plotting out the boundary and marking out the lines. Although in most cases that should already have been done many years ago when the property was first registered. There is another advantage of being on site when the mediation takes place, and that is that I'm often told by participants to the mediation that they have no wish whatsoever to be sitting with the other party. So in that case, I've done many mediations where the parties will sit in their own living room, and I will run in between the two. In some cases, it's quite a long run if it's a large property, but that's what needs to be done. And in some cases, at the end of the mediation, they actually come and sit together when a settlement is reached. Another area of dispute that I get involved in is in the wills, trusts and probate arena. Parties who have recently had to cope with the death of a family member, who are then able to argue amongst themselves about the spoils, or about the dividing up of the will, which is terribly sad. I mean, sad on so many different levels, because obviously the situation is sad after a bereavement, but the fact that it can't be dealt with amicably is hugely sad. But again, I've seen so many of these types of cases, and you just want to scream in some cases and say, what are you doing? This is your family. You're arguing with family members in a way that you shouldn't be. But people, and those of you who are watching this will know that there are so many cases of families who are capable of doing that, and I think you when you're involved as a neutral, you just have to do the best that you can to see or help them see their way through the process. Another question that I'm often asked is how do you do this? It's absolutely fascinating. I often say it's a privilege to be in the middle of grown adults who have lots of business experience, lots of parenting experience, lots of life experience, and they're behaving like kids in the playground and they can't see it. And that's not, that's not to say that we don't all behave like that sometime when we're stuck in the emotion of the situation. But when you're in the middle and you don't know the parties involved, and you don't feel any of the emotion, it's a very liberating experience, and it's a very very free and objective place to be, because I feel that I can only help. I can only help a bad situation. Ultimately, the dispute belongs to the participants, and if they're not willing, or if any one of them isn't willing to find a settlement, then it's not going to settle, because it's a voluntary process. You can walk away at any time, and that has always been one of the strengths of mediation. There's quite a lot of talk about whether mediation should be compulsory. I personally am not in favour of compulsory mediation, in the sense of making people, because you can't make people agree. But what I am in favour of is what's called an automatic referral to mediation, and that means that it will be part of the process before and after proceedings have been issued, that will mean that there will be an automatic referral to mediation, where parties will either have to be advised about the pros and cons of mediation, as they do in the family arena before they issue, or that they will have to attend a mediation meeting itself, and they will have to certify that they've done that. Now we are some way away from that at the moment, but it's something that in my view will be with us within a few years, and we're hoping to learn from all the experience that there has been on this in other countries, where different schemes of mediation referral happening automatically have been tried. So we're coming towards the end of the slot now. If anyone has any questions, please raise them, and I'm happy to answer. I'm going to be at the next Laurel Leaf networking event, so I'm happy to talk this through with any of you who would like to at that point. Okay, there don't appear to be any questions, so thank you very much everyone for listening, watching, and I will see you at the next networking event.